distinguished jury members. We are honored here to be hearing the final round of the moot court. Let me first briefly introduce the faces here who are going to be part of the jury. Of course, they don't need any kind of introduction, but I will do it anyway. Starting by jury members, we are honored here to be hearing that's me. I'm sorry for that. So starting with University Professor Nicolas Forgo, Professor of D and IP Law, Head of the Department of Innovation and Digitalization in Law, and of the University of Vienna. Gloria González Fuster, Professor Dr. Gloria González Fuster, Professor at University of Brussels. And Max Schrems, also, as he said, quoting you, luckily, but not only privacy lawyer and honorary chair of NOI. Dr. Andrea Sabadell, head of the Department in National and International Special Affairs of the Austrian Data Protection Authority. And as well, Claudia, who is also a director at the DPMC, who will support me today. So basically, a brief review of the oral procedures, just to be clear for everyone, and especially the audience here who has not been attending the first round. So we will start formally with an opening of the hearing by the director. We will start with continue with the complainant plea with a minimum of 10 minutes and a maximum of 15 minutes. Followed by the respondent, again with a minimum of 10 minutes and a maximum of 15 minutes. We'll have questions for the complainant and questions for the respondent in a 10 minutes time each. And then the teams will prepare themselves for the rebuttals. They will have 6 minutes each in a breakout room. Here we will have a break where we will allow ourselves to turn off our cameras if we want to. And lastly, the rebuttals by each of the teams closing with a very small statement, including a feedback for both teams by the jury members. With this, I just want to ask the teams here competing if there's any question open regarding the procedures of today. Yeah. Otherwise, we will start with the role and the mood. So, change of role and good evening from my side. My name is Mariana Riseto. I'm a legal officer at the Randomistan Data Protection Authority, and together with my colleagues, we are very honored to hear your complaint today. So please, could you, the claimant, confirm that you are complete? If someone can.
Yes, we are.
Thank you. Could the respondent confirm that you are complete?
Yes, we are.
Thank you. We hereby hereby allow the representatives of Carl Simmons to start a plea. Again, you have a minimum of 10 minutes and a maximum of 15 minutes to start. Okay, sorry, we had 1 moment.
Yeah. Okay.
Well, sorry, 1 moment. We will start the timing again. There is one to remember who.
I had a question. Like, I was asking if we need to wait for Max Schrems or not.
I think he connected already.
Okay.
Okay, Claudia, can you start the timer, please, again? Thank you.
Good evening, Honorable Board and Data Controller Team. I'm Nurlan, Counsel for Data Subject. In the next 15 minutes, we'll argue 3 submissions. In the first submission, I will argue that data published on GM website was personally identifiable to Carl Simmons, so it was personal data. In the second submission, my co-counsel will argue that processing of data from GEON website was in breach of Article 6 GDPR. And in the third submission, my another co-counsel will argue that municipality of Woodville conducted automated decision-making at pre-selection stage of Woodville Goes Green campaign in breach of Article 22 GDPR. Honorable Board, we understand that pollution is a real problem of today's world, and municipality of Woodville wanted to take action against that environmental challenge. But on the other hand, it missed the fact that data is pollution problem of this information age, and data protection is real environmental challenge too. Honorable Board, you know any data which is identifiable to a natural person, directly or indirectly, is personal data. If we find some personal identifiable elements from different parts of a single data set, or even from different data sets, if at the end of the day, if we find a natural person, if we single out a natural person, link this data to a natural person, or even get general inference that all this data are about a natural person, this is personal data. What do we mean? Let's imagine a case. There's a data set with some data. Data are billionaire, a former US president, 77 years old, yellow hair, and something like this. These data are nothing on their own, because there have been many billionaires in the world. There have been 45 US presidents in the history. There are many people with yellow hair and so on. But if we use all this data at the same time, a former US president who is 77 years old now, who is billionaire and who has yellow hair, all we can understand that I'm talking about Donald J. Trump. This is the case. This is what I'm talking about. In this case, municipality of Woodville extracted some data from GEON website. Data are many, but 3 of them was personally identifiable to Carl Simmons. The first data is activity type. You know, Woodville is a small town having only 47,000 inhabitants in total. And hunting is a licensed activity in Woodville. This means that there are not many hunters in Woodville. How many are they? 15, 50, 70, or even 100? Even if we say 100, it's still very few. This means that at the end of the day, we will have a data set with exactly 100 people at hand. The second data is name. You know, Carlos Bachelor Ltd is a very small business, owned and managed by a single family. It is one-man company having only 4 employees. The employees are Carl Simmons, his wife, his son, and his wife. This means that the company is one-man company. And it's very likely that this small business derived its name from its owner's name. And it's true. In this case, the business name is Carlos Battery and its owner's name is Carl Simmons. So if you say Carlos Battery in Woodville, everybody will have an inference that its owner's name is Carl. And it's true. So the Carl, the identifier here, is personal to Carl Simmons. And third data is address. The address of Carlos Bachelor Ltd, the business, and its owner, Carl Simmons, has the same. So they share the same address. Again, it's a very small business. It's a one-man company. And it's very likely that that small company shares the same address with its owner's address. And it's true, in this case, both the business and owner shares the address, Town Street 22, 1234, Woodville. So what do we get? There is this natural person whose name is Carl, who is a licensed patcher in Woodville, and whose address, or at least who has business at the address of Town Street 22, 1234, Woodville. If we use all this data at the same time, then we will understand that I'm singling out Carl Simmons, and these data are linkable to Carl Simmons. So all this data are personally identifiable to Carl Simmons, and these are personal data. Thank you for your attention. My co-counsel will continue with his own submission.
Good evening, dear members. My name is Kanan, and today I'm appearing on behalf of the claimant, the data subject. We submit that the processing of personal data by the municipality does not fall under any legal ground set out in Article 6.1 of the GDPR. According to Article 6.1 of the GDPR, the processing of personal data is lawful under specific legal grounds, the so-called legal basis. And this legal basis should be clearly communicated to the data subject in accordance with Article 13 of the GDPR. And in its privacy policy, the municipality has identified 3 legal bases to justify their processing of personal data, which are: first, contractual necessity; second, legal obligation; and the third, public interest. As for the first legal ground, the contractual necessity, under Article 6.1b of the GDPR, the processing of personal data is lawful when it is necessary either for the performance of a contract, which is not the case here because there is no contract yet to perform the obligations therein, or if it is necessary to take the pre-contractual steps at data subject's request to enter into the contract. And according to the European Data Protection Board's guidance, the processing, which is useful but not objectively necessary, is not covered by this provision. Similarly, the municipality could have conducted the preselection process without the need to process the personal data from the GION's website. With the available information only, they could have conducted this preselection process. The municipality's aspiration to support more eco-friendly businesses is probably useful for the selection process. However, it's not a necessary requirement to enter into the funding agreement. As for the second legal ground, the legal obligation, we submit that the legal obligation, it should have been the case where the municipality had no choice but to comply with the legal obligation at hand. But the legal obligation we are talking about here comes from a decree which was adopted by the municipality itself. Therefore, municipality could have easily modified its content or set that decree aside in its entirety. Therefore, we conclude that the municipality was not under the pressing legal obligation. As for the last legal ground, the public interest, under Article 6.1e of the GDPR, the processing of personal data is lawful when it is necessary for the performance of a public task carried out in the public interest. And in order to achieve full compliance with this legal base, the full compliance with the principles set out in Article 5.1 of the GDPR should also be achieved. And the first of them is the data should be processed lawfully, fairly, and in a transparent manner. In order to assess the lawfulness, the necessities should be conducted, which means the least restrictive measure should be employed to achieve the identified purpose. And the purpose here, the purpose of the processing of personal data as established in the privacy policy is selecting and funding green investment, not the green businesses. However, the measure taken by the municipality, processing of personal data from the GION's website, helps to identify more sustainable businesses, not the green investments. If, therefore, it was unnecessary to take this measure to achieve the identified purpose. If the purpose of the processing was identifying sustainable businesses, then this measure could have been necessary. As for the second principle under Article 5.1 of the GDPR, the purpose limitation, which means the controller should identify the purpose as specific as possible. And the compliance with the purpose limitation principle also leads to the third principle, which is data minimization, because once you have identified and understood your purpose as specific as possible, it guarantees that no more data than necessary will be processed. However, in this case, the processing of personal data from the GION's websites helps to identify most sustainable businesses. However, it doesn't tackle any issues stated in the purpose section of the privacy policy. Neither it helps selecting and funding green investments, nor it reduces the carbon emission as a whole. Therefore, we submit that the way data are collected and processed are excessive, also are irrelevant. The reasonable person in Carl Simon's place would unlikely anticipate that the processing of personal data from the GION's website would play a decisive role whether he gets the funding or not. Thank you for your attention, dear jury members. My co-counsel, Elvin, will continue with the automatic decision-making issue.
May it please the Honorable Board, my name is Elvin, and I will proceed to the third submission of the data subject in today's proceedings. In relation to this submission, we firstly present that Carl Simons was subject to automatic decision-making in the selection process conducted by the municipality of Woodville, and secondly, such automated decision-making shall not benefit from the exceptions under the Article 22 of the GDPR. And may I seek your permission to address my first argument? Honorable Board, the automated decision-making systems are generally prohibited under the Article 22 of the GDPR, and namely, two conditions shall be met for the application of this prohibition. Firstly, a decision based on solely automated processing, and secondly, existence of legal and similarly significant effects over the data subjects. And in this respect, we submit that both of these conditions are applicable in our case. And may I explain them respectively? With respect to the first condition, it means that there should be no meaningful human involvement in the automated decision-making systems. And in this regard, we submit that this condition not only covers the single step, but also multi-stage automated decision-making systems, in which the human intervention and automated processing can happen in different stages, and the final decision is preceded by the initial decisions, which are fully automated. And the crucial factor is that the preceding decisions have the significant effects and influence over the final one. And Honorable Board, the selection process conducted by the municipality of Woodville fall inherently under the multi-stage automated decision-making systems. Firstly, the applications go through the pre-selection process, which are fully automated, and only the successful ones are presented to the final decision of the committee. And as we see that, final committee decision is significantly influenced by the preceding automated pre-selection. Therefore, the first condition is met. And with respect to the second condition, the automated decision-making systems in the selection process resulted in having the legal and similarly significant effects over Carl Simmons. On the one hand, Carl Simmons is deprived of his legal right to access to public funding, and on the other hand, he is exposed to severe financial burden due to the rising energy costs in the future years. And therefore, Honorable Board, both of these conditions are present in our case. And furthermore, the GDPR provides 3 exceptions for the application of this prohibition. And we submit that none of these exceptions is present in our case. The first exception relates to the contractual necessity. And as my co-counsel cannot present it during his second submission, there is no contractual necessity at all in our present case. And second exception means the existence of explicit consent on the part of the data subject. And in this regard, we first submit that consent is not the valid and appropriate basis here, because municipality of Woodville is a public authority, and therefore there is inherent power imbalance between the data controller and data subject. In any case, we secondly submit that Carl Simmons has never explicitly consented to the automated decision-making systems in our present case. Last but not least, the third exception means the authorization of the automated decision-making systems by the member state law, which at the same time lays down the adequate safeguard measures for the protection of the data subject's rights. And in this regard, we first submit that the municipal council decree, in our case, prescribing the automated decision-making systems is not qualified as the member state law, since it was not adopted by the Republic of Randomizan itself. In any case, we secondly submit that the municipal council decree lacks any adequate measures for the protection of the data subject rights, such as the right to obtain human intervention, right to express his or point of view, and right to contest the automated decision-making systems. Honorable Board, as concluding our submissions, we respectfully request the Data Protection Authority of Randomizan to find, declare, and decide that the municipality of Woodville conducted the unlawful data processing in the selection process, and during this process, it shall stop using the information from the JOHN website and the automated decision-making systems. Thank you so much for your attention.
Thank you very much. Now, the representatives of the municipality of Woodville, you have the floor. Again, a minimum of 10 minutes, maximum 15.
Thank you. Greetings. My name is Nazar Duchak, and today, together with my colleagues Eliza Rohotzka and Anastasia Tokareva, we'll be acting on behalf of the data controller, the Municipal Council of Woodville. I will start with the essence of the case and will cover the issue of personal data. My colleague Eliza will prove that the personal data was processed on the proper legal basis, and Anastasia will explain why the usage of automated decision-making was justified in the present case. Let me start with the essence of the case. In order to save the town of Woodville from the harmful effects of global warming, the data controller initiates the Woodville Goes Green campaign to fund the local green investments. As the municipality's resources are limited, it is essential to guarantee an equal selection of the most trustworthy applicants. Last year, the selection was done manually and led to a public scandal, when the mayor's son received the funding without even remotely meeting the funding criteria. For this reason, when the budget was increased by €2 million, the data controller had to provide a transparent selection, and it was based on the relevant public information and verified customer feedbacks, including about Carl's Battery Limited. To put it on a map, the data controller agrees with the data subject that name, address, and activity type are personal data in the present case. At the same time, the data controller sees that the primary dispute here is not the alleged data by the data subject, so like name, address, and activity type, but rather the GUI/UN input, rather scores, ratings, and comments, which were not even claimed to be personal data by the data subject, as based on them, automated decision-making was done. The position of the data controller is that the GUI/UN input is not personal data, except for 2 comments. Secondly, the personal data was processed on a proper legal basis. And thirdly, Mr. Carl Simmons was subject to automated decision-making by the municipality. That was for the entering into the contract, and that was justified as there were relevant safeguards. However, in light of the recent judicial practice, the data subject should have first addressed the GUI/UN as an independent controller who firstly conducted automated decision-making. This follows from the recent decision issued by Court of Justice of the European Union, namely Schufa case, that when the third party, which is GUI/UN in our case, conducts automated scoring, such automated scoring must be considered as automated decision-making. And returning to personal data, the data controller agrees with the data subject that name, address, and activity type can be considered personal data in the present case. However, scores, ratings, and comments are not, except for 2 comments. According to Article 4 of GDPR, personal data means any information relating to identified or identifiable nature of person. In terms of relating, according to the Article 29 working party opinion, the information relates to a person if it either says something about the person, it evaluates the person, or it causes a different treatment for the person. However, in our case, that did not happen to any specific nature of person. That is because the GUI/UN input does not lead specifically to Mr. Carl Simmons, as besides him, his wife Linda, their son Tim, and Tim's wife Sarah work at Carl's Battery. Thus, the information rather relates to a group of people and the established business practices in Carl's Battery Limited. The data controller also emphasizes that the personal data protection laws only apply to nature of person. Still, according to Article 29 working party opinion, there can be some exceptions. The first one is when the name of legal person derives from the name of nature of person, and the second is when the information is about a small business, which may disclose the behavior of its owner. Regarding the first exception, there is an open question whether the business was named after Carl, because Carl was born in 1966 and the Battery was established in 1959, 7 years earlier. Regarding the second exception, the feedback about the business does not describe Carl Simmons' behavior. As mentioned earlier, the information instead describes the performance and environmental practices of the business and the group of people involved in it, and not of Carl or any other individual. Thus, the data controller submits that the personal data in our case is limited to name, address, activity type, and 2 comments provided by GUI/UN. With that being said, I'm happy to pass the floor to my colleague Elisa. Thank you.
Honorable jury, as it has been previously mentioned, I would act for the data controller, proving that the alleged data was processed on proper legal basis provided by Article 6.1 of GDPR. I would devote my speech respectively to these bases. First of all, I would prove that the processing was necessary in order to take legal steps at the data subject's request prior to entering into a contract. Then, I would describe the legal basis of the public interest, and finally, I would argue the need for compliance with a legal obligation. But just before I start my plea, the data controller would like to stress on the concept of necessity, which is crucial for all 3 legal bases. European Data Protection Board interprets necessity as a combined fact-based assessment of the processing for the objective pursued and of whether it is less intrusive compared to other options for achieving the same goal. Accordingly, the data controller states that the processing falls in line with Article 6(1)(b) of GDPR, as it was necessary in order to take legal steps at the data subject's request prior to entering into a contract. This legal basis includes two major points: request and less intrusive means. Firstly, the processing shall be regarded as pre-contractual, as the data subject did not get to the stage of a valid contract. However, Mr. Simmons has applied for it on the website, requesting the data controller to take legal steps in his particular need for green incentives. Secondly, the data processing could not benefit from the less intrusive means. The data controller has already presented one in its written reply to let Ms. Winter decide on the candidates herself. However, such an alternative of excluding the usage of GYON input definitely would not help the municipality to reach its goal of the objective, transparent, and namely effective allocation of the public funding. Moreover, subjective decision could become a ground for a new scandal. As the processing benefits from the request and absence of less intrusive means, it was necessary in order to take legal steps at the data subject's request prior to entering into a contract. Additionally, data processing was necessary for performance of a task carried out in a public interest. According to Article 6(1)(e) of GDPR, no matter what the public interest is, the processing must be necessary for this very public interest. The data controller had the name of becoming the first carbon-neutral town, and it had several reasons for it. It had suffered much in the recent years due to global warming, which affects the town's economy badly. Many locals lost their jobs and quit them resentfully. The resources for funding are limited, and the municipality strives to avoid terrible mistakes of the past, namely the political scandal of August 2022. There were no less intrusive ways of data processing, whereas there was a combined and fact-based assessment of the processing for the objective pursuit. Finally, processing aligns with Article 6(1)(c) of GDPR, as it was necessary for compliance with the legal obligation to which the controller is subject. According to Working Party 29 opinion, legal obligation can be based on the additional legal act under public law, such as secondary legislation. This lets the data controller use the provisions of Decree 65/2023, which clearly describe the means of preselection. According to the facts of the case, the municipality had powers to adopt the decree itself. Moreover, the municipality's decree was in line with European Union and member state law. It obliged the data controller to conduct the preselection automatically based on data from GYON and decide on funding requests. Hence, the municipal council had the legal obligation as for the processing of requests, which serves a legal basis for data processing. Last but not least, following the mentioned argumentation, the data controller has complied with alleged data processing principles. The data controller has lawfully collected an adequate and reasonable amount of data for the purpose pursued. Data was limited to the minimum. Moreover, green investments have to be given to green businesses. That is why the purpose of such processing was sufficiently stated in the privacy policy. Consequently, the data processing shall benefit from the subsections B, E, and C of Article 6(1) of GDPR. Now I'm happy to pass the floor to my colleague.
Honorable jury, my name is Anastasia, and I am playing for data controller and will be presenting the automated decision-making part. To continue the argument, the data controller stated that the automated decision-making was present exclusively in the GYON pre-selection process. However, the decision-making from the municipality side was done in compliance with Article 22 of the GDPR. Firstly, there was a necessity to enter into a contract, precisely the intention to enter it. Cross-Butcher Limited has applied for funding by fulfilling the application form, meeting the criteria from two hyperlinks from the website, the decree and the privacy policy. Consequently, the processing shall be regarded as pre-contractual. The data controller has an obligation to prove that this type of processing was necessary and there was no other options to reach the fair results. First of all, both the parties knew about the corruption-related political scandal of August 2022, which was posted in a newspaper. Regarding this, the municipality's aim was to create the equal playing field for all participants of the funding. It was also vitally important to receive the side point of view about businesses for customers' reviews, so the data controller would be unbiased and objective. Thus, the necessity of pre-selection process is justified. Secondly, the data controller should provide the data subject with required safeguards as human intervention and the right to contest the decision. To elaborate more, the data controller attached 3 employees, including Charlotte Winter, to double-check the GIM calculated score. But the cross-budget limited score was even lower than the half. It was 234 from 600, so there was no reason to adopt it. Of course, the data subject had an option to challenge the decision if they didn't fully understand the way it was made. But the data controller would like to stress that cross-budget limited were aware of being involved in the automated pre-selection process, the envisaged consequences, and explained the logic of the decision. All of these points were mentioned in the decree and privacy policy. The data subject was informed about the criteria on which the automated decision-making will be based: GIN, commercial, and insolvency registries. It's important to mention that data controller has no obligation to disclose the full algorithm. In addition, the automated pre-selection process was sufficient because of this year's increased budget and unwillingness to repeat the mistakes of previous unsuccessful funding. Hence, the data subject was provided with all required safeguards. Thirdly, the data controller reached all the necessary notification obligations, so the data subject could foresee the potential effects for themselves and lodge a complaint to contest the decision. In the circumstances of the case, businesses which do not meet one of the criteria of the funding lose their possibility to participate in this year's VGG campaign. Beyond that, if the data subject does not agree with the decision, they can exercise their right to object or restrict the processing and apply to the DPA. Thus, the notification obligations were observed. To sum up what was said earlier, the data controller denies presence of personal data in scores, ratings, and comments, except 2 of them. Speaking about name, address, and activity, there was a legal basis as public interest and entering into a contract and performance of legal obligations. The process of automated decision-making was followed by safeguards as human intervention and the right to contest the decision. The necessity of entering into the contract was present as the notification obligations were met. Thank you.
Thank you very much. Now we'll have 10 minutes for questions to the complainant. Is there any jury member who would like to start with questions? Yes, Gloria, please go ahead.
I will start with a question for the first team. Could you clarify, have you changed your request in relation to the written submission? Because in the written submission, you just wanted to stop with the automated decision making, and now you said something about requesting that they stop using some information. So what is exactly that you're requesting? Are you requesting that the municipality stops processing some data, or you're just contesting the automated decision making? Thank you.
Thank you so much for your question. We request the Data Protection Authority of Random Island to find, declare, and decide that municipality of Woodville shall stop using the information from GION website and shall stop using the automated decision making in the selection process.
But the data subject did never actually submit an erasure request, or they didn't exercise the right to object directly. You're just now coming to us, but there was no erasure request or no right to object request, was there?
Yes, Your Excellency. We object to the data processing activities conducted by the municipality of Woodville, and as a result of these data processing activities, firstly, the unlawful data processing is conducted, and secondly, as a part of this unlawful data processing, the information is used from the GION's website, and automated decision-making systems are utilized during the part of the unlawful data processing. And therefore, we request the Data Protection Authority to firstly find, declare, and decide that the municipality of Louisville shall stop using the information from GEON website, and secondly, shall stop using the automated decision-making systems.
Yeah, Andreas.
Yeah, thank you so much for your contributions. Just one question, because in your written submission, you claim an infringement of Article 13 and 14 GDPR. And I just wonder, what is the impact of such infringement regarding the lawfulness of the processing? So in your view, do you mean that if the information obligations are infringed, this leads to an infringement of Article 6 as well? And if so, what are your reasons for that? Thank you.
Thank you for your question, dear jury member. We would like to submit that under Article 13 of the GDPR, under Article 6 of the GDPR, there are some grounds which make the processing lawful, and this legal basis, alongside with the purpose, should be clearly communicated to the data subject in accordance with Article 13 of the GDPR, because the data processing should be in a transparent manner under Article 5.1a of the GDPR. I hope it helps your question.
Well, not entirely. Let me ask maybe a second question in this context. What I mean is that in your written submission, you claim an infringement of Article 13, but there's no further explanation on the impact this infringement has. So yes, we have an infringement of Article 13, but what does it mean for your complaint? Does it mean that an infringement of Article 13 is also an infringement of Article 6 automatically? And if so, what are your reasons for this?
I would like to address this question, Your Excellency. Firstly, we submit that as a result of the infringement of the Article 14 of the GDPR, the municipality of Woodville has infringed and has violated its notification obligation with respect to the automated decision-making systems, because the GDPR has provided the obligatory notification obligation with respect, particularly the meaningful information about the logic and, of course, the factors taken into account during the calculation and during the automated decision-making systems and their aggregate level for the data controller, and to provide this information to the data subject. And this is clearly implies the lawfulness of the data processing activities with respect to the automated decision-making systems. And we submit that it's a part of the lawfulness of the automated decision-making systems in this case. And regarding that, the data controller has not met its notification obligation. It means that the automated decision-making systems hasn't been used in a lawful manner in our case.
All right, thank you so much.
Yeah, thanks, go ahead.
Thanks a lot already. I would have two short questions. First of all, the question of necessary underneath the law. I mean, in some member states, we have statutory instruments, we have local laws, we have local implementations, a lot of that. Would your submission be that, whenever someone, so to say, drafts a legal obligation, that it also enforces, this would always be null and void or could not be used, if I understand that correctly? The second question I would have is for the human intervention that's also in your written submission. If you read Article 22, paragraph 2 and then 3, you see that these requirements that you say they have to put in are only there for A and C, not for B, and it seems there's a bit of a mix-up. I don't know if you could clarify these two issues. Because I just see general safeguards you need for, if it's based on member state law, not that it specifically has to be, for example, human intervention.
Thank you, dear jury member, for your first question. I would like to say that, well, the necessity requirement has been established by the community law, by the European Court of Human Rights. And according to this principle, the necessity this test, they have, for example, the European Court of Human Rights has identified 3 tests. They should be pressing social need. The measure taken should be proportionate. Also, they should be relevant real-world reasons why this measure has been taken. I believe that this is the test we should follow today. As for the legal obligation ground, as we submitted, the legal obligation is coming from a decree which was adopted by the municipality. If today you let them go away with that, any municipality who wants to process the personal data would adopt their own decree and start processing personal data. Okay, that was my answer.
Okay, and with respect to the meaningful human intervention, and I would like to mention that under the Article 22, Paragraph 3 of the GDPR, namely, it's mentioned that in the cases referred to under Article 22, Paragraph A and Paragraph C, the data controller has provided the adequate safeguard measures for the protection of data subjects. But it doesn't necessarily mean that the point under the Article 22 Paragraph B of the GDPR is excluded from providing the adequate safeguard measures, because it's explicitly mentioned under the Article 22 Paragraph B of the GDPR. The member state law shall include the adequate safeguard measures with respect to protection of data subjects' rights. And these adequate measures include the right to obtain human intervention and the right to contest the automated decision-making, and etc.
Yes, please.
I have a very brief question going probably in the very same direction. Thank you very much for this. And that's about Article 22, Section 1, and the word solely in it. I didn't hear too much about why you are of the opinion that the data subject was here subject to a decision based solely on automated processing, because I think that there was quite some communication ongoing, and I would appreciate some more comments on this. Thank you.
Thank you for your question. And we submit that the automated decision-making based on the decision based on solely automated processing is present in our case, since firstly, there was no meaningful human intervention on the part of the data controller. And secondly, it is the multi-stage automated decision-making systems. And the preceding decisions have the significant effects over the final decision of the committee. And of course, it is prescribed by the SHUFA judgment, by the recent judgment of the European Court of Justice in the SHUFA, the preceding decisions, if the preceding decisions or the preceding scores have the significant effects over the final decision of the committee or final decision of the human intervention, it's called as the decision based on solely automated processing. And with respect to the first point, there was no meaningful human intervention because the employees on the part of the municipality of Woodville only merely applied the automated preselection decision, and not only substantively evaluate and assess these decisions. And therefore, they have the just formal character, not the substantive character.
Thank you.
Thank you very much. So the time for questions to the respondent is on. And yeah, if everyone would like to start from my juries. Thank you, Andres.
Yes, thank you so much again. I just have one question, and the question is, how do you ensure compliance with the principle of data accuracy? In other words, in your view, is it not problematic that you take opinions of customers as basis for the decision whether to grant public funding or not? Thank you.
Thank you for your question and for an opportunity to clarify it. The data controller uses the subjective feedbacks left on the GYON, firstly because it is verified. The customers who leave it, they are required to also upload a receipt concluding that they have been using this service. And at the same time, it is important to state the reason is that they have been verified.
All right. Thank you.
Yes, Gloria, go ahead, please.
Thank you. I had a question on the argument about compliance with Article 14. So transparency obligations. I think it was the last speaker. You mentioned that actually everything is clear in the privacy policy. And I have checked again the privacy policy, and I don't really see a mention at all of automated decision making, or the fact that one can contest this decision based on automated decision. There's a reference that we will use some information coming from other places, but it doesn't really say that there is some automated decision making, and these will be the effects. You said, well, people can figure this out by themselves, but of course, that's not what the GDPR says. The GDPR says you have to explain to people what are the consequences. So could you tell me, where do you see compliance with Article 14 in the privacy policy?
Thank you for your question. Actually, we would like to clarify that the data controller had an obligation to provide information about what was going to be involved in the pre-selection. And actually, it's not only the privacy policy. We also have the decree, which the municipal council had adopted. And the hyperlink to the decree and also to the privacy policy were provided. Of course, we can agree that there's always a room for improvement in any privacy policy, but still the data subject was provided with the information, and that is why we have complied with Article 14.
But would you say that that is to facilitate information in a clear, intelligible way, that you're really making information available by providing an hyperlink to a decree that people will probably not read?
Actually, it's the responsibility of the reader, but still we can refer to Recital 58, which can explain us what is the information which is provided in a transparent, easily accessible and intelligible way. And this recital provides us with the information that it may be published on a website. Such information is provided in electronic form, and it is our case because we have provided the information via the hyperlinks.
Thank you.
If possible, one quick question still on the and can you not just shift the responsibility to the original source if that's your source? I was wondering about that comment in the statement.
Thank you. The data controller is definitely liable, and we acknowledge this. However, what we meant is that from the recent decision of the CJEU, which was also mentioned by the data controller, that the data subject should have first addressed the GYON. Even though he can still address us, but we believe that it would be rather better to address the GYON first, that he is the first automated decision maker according to this decision. And I would like to also, if I have an opportunity to complete the answer to the previous question, I'm very sorry for the interruption. The first one is that the information is verified and there are relevant safeguards posed by the GYON. And the second is that the amount of defining power that those sections has only 25% out of the whole GYON score. Thank you.
Can I simply ask? Okay, so I actually my question is going quite in the same way like the one that I asked the other team before, which is the other team. So the claimant was rightly mentioning the recent Schufa case from the Court of Justice of the European Union, which is a very interesting decision for this case. And as far as I remember, it was published right after your opinions were written. So my question to you is whether there is any reason to change any of your argumentation because of the most recent developments of the Court of Justice of the European Union, or whether you stick with your arguments as you did it in writing.
Thank you for your question. We have adjusted our position accordingly, and according to this position, we state that we have conducted automated decision-making. In our written submission, we have an alternative argument that we were either both conducting or not conducting, but at the same time, we complied with all the obligations due to the high standards that are relevant and that are usual for the data controller. And we have added to our position the fact that the data subject should have first addressed the GYUN in light of this decision.
Thank you.
I think we have still a time. I have a question. Perhaps this one. You state that different kind of information is considered personal data or is not, and how do you think this argumentation is relevant for the prohibition of Article 22? Whether what kind of information is personal data or not, what is the point of argumentation that you want to strengthen here? That was for me not that clear. Thank you.
Thank you for your question. So either the whole GYUN input or only the 3 comments are personal data in terms of automated decision making makes a difference, because it shows what amount of personal data was processed by the data controller, and the less is better for sure. Thus, we conclude that the only 3 comments out of the GYUN input were personal data in the present case.
Thank you. If there are any questions, we have a little bit of more time. Otherwise, no. We thank you very much for your fee and replying to questions. I will go to a breakout room for preparing for the rebuttal, and this will start the claimant. For the rest of us, we'll have 6 minutes of break. Thank you. May I ask Professor Fuego to give the host rights to Claudia? Thank you. Sorry for that. Claudia?
I hope it worked.
Okay, thank you. Thank you very much. Now we have a short break. All right, and so the co-creating team should be back. A couple of seconds now. Thank you all for your patience. Okay, so thank you very much. I hope that you can hear me. Welcome back. And as soon as the timer is on, you may start your rebuttal.
Good evening again, Honorable Board and Data Controller team. Data Controller team argued in their oral submission that in Shufa case, data subject applied to the Shufa, not the bank, another data controller. So in this case, Carl Simons should have applied to GION, not the municipality. But the difference between that case and this case, in that case, there was automated decision-making only in part of Shufa, not the bank. But in this case, automated decision-making is present both on GION side and in the municipality side, as it's proven by the municipality decree. In that decree, the municipality clearly says that at the preselection, the municipality of Woodville conducts the automated decision-making. And another distinction is that in that case, the data subject was challenging the logic behind the automated decision-making on the Shufa side, the score, how to calculate the score. But in this case, Carl Simons is not challenging the calculation logic behind the GION scores, but how it is applied. As for the second rebuttal, data controller argued that the data from GION website was enough to identify a whole family, not Carl Simons. But they missed the fact that only one of the family member is named Carl. So if the data controller agrees that those data were enough to identify the family, it means that this data, as the name of the business was Carl's Battery, was also enough to identify simply the Carl. Thank you.
Dear members, I will address the issues regarding the the basis of the data processing. As for the first legal base, the context necessity, the data controller team argues that as an alternative, as a less intrusive means, the Miss Winter, Charlotte Winter, could have conducted the preselection process, but she had the personal ties with the Carl Simons. However, we argue that Miss Winter is not the only employee of the municipality. Okay, the other persons could have conducted the preselection process as well. Or alternatively, less intrusive measure, they could have established a committee, working committee, and they could have conducted the process, preselection process without the need to process the personal data from the government's website. As for the second legal base, the public interest. Dear jury members, the public interest here is reducing carbon emission. Imagine that I'm the Carl Simons. If you provide the funding to me to provide the funding for my project will also equally contribute to reduce the carbon emission. Then how they measure the processing personal data from GION's website is necessary to aid, to help to achieve the reducing carbon emission. Also, the purpose in private sports is completely different. It is selecting and funding green investment, not selecting and funding green businesses, which processing of personal data from GION's website helps to achieve. As for the last one, the legal obligation, the data controller team argues that there is a clear legal obligation because there is a municipality's decree. The municipality decree, as it is self-explanatory, has been adopted by the municipality itself. Then, if you today decide that it's a legal obligation, any public authority which aims to process the personal data and cannot get the consent, for example, contracts necessity or legitimate interest, fails to satisfy legitimate interest, they could adopt a decree and start processing personal data unlawfully. Thank you for your attention.
Honorable Board, I will address the 2 points with respect to the automated decision-making as a response to the oral submissions to the data controller. Firstly, we submit that the data controller has not met its notification obligations under the Article 22 of the GDPR. With respect to this article, the data controller shall provide some meaningful information about the logic and notably the factors taken into account on the calculation and the automated decision-making and their aggregate level during the automatic decision-making systems. But in our case, the only document which prescribes these information is the municipality privacy policy. But we see that the municipality privacy policy doesn't say anything about the automated decision-making systems, and specifically about the logic and the factors on the aggregate level. And secondly, we submit that there is no meaningful human intervention on the part of the data controller. And the data controller has submitted in its oral submissions that the 3 employees are allocated for evaluating the automated decision-making. But I would like to draw your attention to the fact that the Article 22 of the GDPR not only requires the human intervention, but meaningful human intervention. But in our case, these employees only rely on the GEON score and automated pre-selection decision and just merely applying them. And therefore, their role is just a formal character. And therefore, it's not called as the meaningful human intervention in our case. Thank you so much for your attention.
Thank you very much. So we have now 5 minutes for questions. Thank you.
Shall I go ahead? Yes.
Yes, please.
I was a bit confused. So the first argument was that there are 2 different automated decision-making processes, one by GEON and one by the controller. But then at the end you said, it's just the municipality is just taking the score and applying the score, and that's it. So could you clarify this? Are you claiming that there are really 2 different decisions taken and that are a problem for you, the scoring by GEON and then something that the municipality does, but at the same time, you said the municipality doesn't do anything else than just applying this score. So does that make sense?
Sorry. Thank you for the question. In this case, there are 2 distinct data controllers. The first is GEON, second is municipality. Of course, GEON conducts automated decision-making and calculation of the scores, GEON scores. This is automated decision-making. But in the other part, the municipality also conducts the automated decision-making in the pre-selection. For example, there's a logic, if I don't make a mistake, as the municipality was not transparent to us about the logic of the system. But what we understand is that there was a system where only the scores more than 400 passes to another stage. So this was automated decision-making with no meaningful human intervention. In that case, in Shufa case, the data subject challenged the logic behind the credit score. In this case, if Carl Simon had challenged the logic behind the GEO score, it would be applicable. Then Carl Simons should have sued the GEON. But in this case, Carl Simons is challenging the automated decision-making used by the municipality, not the GEON. There are 2 distinct data controllers and 2 distinct automated decision-making. And we are challenging the part of the municipality.
Thank you.
Thank you.
Yes, Andrea, sorry.
Yes, you said that there was no right to obtain human intervention. But if we have a look at Article 12.2, it could be said that in order to receive human intervention, in a first step, you have to submit a request to the controller. So my question is, how is this in line with your arguments?
Thank you so much for your question. And we submit that the automated decision-making processing is conducted in such a manner that the data subject can request the data controller to obtain the human intervention. But in our case, the application is different because the data controller has submitted that there was no automated decision-making on the part of data controller because the 3 employees are allocated for the automated decision-making and they exclude the existence of the automated decision-making systems. But we submit that such human intervention is not a level that which excludes the existence of the automated decision-making systems, because their role is just a formal character, and they just check the Dion score and automated pre-selection decisions, and the applications are determined just only based on the Dion score and automated pre-selection decision, not just the individual human assessment and evaluation of these employees. And we submit that the allocation of 3 employees do not exclude the existence of the automated decision-making process.
Thank you.
If I may, one last time digging into the abusive degrees. It's basically just the fact that you're processing the data, plus you're also setting the rules, which we have hundreds of times in social health insurance companies that make their rules, all kind of different government bodies that make rules that you then have to process data under. Is there any option that anybody ever uses data anymore if they also set the rules for this data processing, or is that like always prohibited in your view?
Excuse me, I really couldn't catch the question.
I think we're out of time anyway. Sorry for that.
We're out of time. Yeah. Thank you. All right. So we'll have, thank you very much for everyone. We'll have 6 minutes for preparation time for the respondent team now, and the rest will have a short break. Thank you very much. Our time is up. Thank you very much. I think we are all, and we may start with the timer for the result of the respondent.
Are we waiting for Max?
Oh, sorry. Yeah. Thank you. Thank you, Victoria.
Thank you. On behalf of the data controller, we would like to follow the same structure offered by the data subject. I'll be presenting the first issue about the application of the Schufa case and then the identification of Mr. Carl Siemens. My colleague Elisa will prove the third and fourth and fifth element, namely about that Mrs. Winter is not the only employee and how the measure was necessary, and about the legal obligation. And Anastasia will cover the last two issues about the notification obligation and about the human intervention. Starting with the first one, with the application of the Schufa case in our situation. Truly, the difference is that in the Schufa case, the automated decision-making was fully on part of Schufa, not on the bank. Here, we have the situation when two parties conduct automated decision-making. What we apply from the decision is that the determining role in the decision-making process is it has a high determining role. For example, the data controller applies here a score as an important part of it. It is not the only source, but it is an important element. And according to the logic expressed in the decision, both parties are conducting automated decision-making in such a situation. And that applies to our situation, that the score provided by GYON has an important role in the final decision-making, and thus the GYON also conducts automated decision-making. And for this reason, the data subject should have first addressed the GYON. In terms of the logic, my colleague Anastasia will provide you in more details further. As for the identification of Mr. Carl Siemens, the fact that he's the only one Carl named in the family, firstly, we are limited to the facts of the case, and we don't know, maybe there were other Carls, but at the same time, the data controller submits that as the information rather relates to established practices of business and not exactly to Carl. Firstly, it is not obvious from the beginning who is the owner, and the fact that the battery is named after Carl and not named after Carl, the fact that battery is named Carl's battery does not mean that it is easily understood that he's an owner of the battery, because he was born after it was established, and at the moment of its establishment, it was impossible to derive the name of the battery from his own. Thank you.
Honorable jury, I would like to disapprove the data subject's claim and prove that the alleged data was processed on proper legal basis. As for the first issue, Charlotte Winter was not the only employee, and others could check the decision. Actually, there were 3 employees, and the third speaker of your team has mentioned this. So you know about this fact that there were at least 3 employees. Also, about the proposition on the committee, actually, the municipality had provided the committee a procurement committee, which could check. It was the second instance of checking the applications, but just before that, there were 3 people. It was randomly allocated which employee would get this application. As for the second issue, about the public interest, you're also claiming about the purpose, selection and funding green investments. However, the data subject was notified that it's not only the privacy policy which says green investments, but it's also the decree which says green investments by businesses. And there are also articles which said which businesses are supported and who is the subject of funding. It is a business indeed. Finally, as for the legal obligation, the municipality's decree has been adopted by the municipality, but still, as we have already mentioned, the municipality had power to adopt the decree. And according to the facts of the case, the decree was in line with the European Union law and also with the law of randomiston. That is why we are concerned that the legal bases were followed, and we had the 3 legal bases of legal obligation, public interest, and contract necessity. Thank you.
To continue the arguments, the side of the data control would like to stress that the data subject was provided with the logic involved in the automated decision-making. And our logic of automated decision-making is based on 3 main criteria: the GION score, the insolvency, and commercial registries. According to the argument about the notification and the meaninglessness of the involving Charlotte Winter, the data controller would like to stress that the involvement of the Charlotte Winter was meaningful because she and two other employees had the right to reject the application or the right to forward this application further, even the GION score is not like the whole score is not high enough, but they didn't. And also, according to the notification obligation about the decree and privacy policy, the decree describes the main criteria on which the automated decision is based. But the privacy policy involves other options which are attached to the automated decision making. For example, we have the purposes of and the legal basis of automated decision making. We have the collected data which we use to provide to make the automated decision making, and other criteria which are attached to the process of automated decision making. Thank you.
Thank you very much. So we open now the round for questions. One third. Yeah, Gloria, go ahead.
Thank you. So the first speaker has now embraced this idea that there are two moments of automated decision making, but that one is like more important and predominates on the other, that the GION is adopting this score, and then the other follows necessarily from this. So then it must mean that nobody at the municipality has the right to actually question this score. You only have the choice to perhaps ignore the score, but you don't know the logic of this predominant automated decision making that just comes to you. You cannot question it, you cannot do anything, you have to accept it. Is that right?
Thank you for your question. The data controller actually understood how the GION score is calculated. It is based on the user's rating, publicly available information, research on carbon emissions, and information from the insolvency registers. So like the municipal council actually understood how the score is calculated, and at the same time, the municipal council provided an opportunity for the data subject to appeal the decision. If there is something that the data subject claims to be incorrect in this decision, the municipal council can review this accordingly. And at the same time, the municipal council has told and instructed its employees in the fact that they believe that something is wrong with those scores, they can still pass it to the procurement committee, and thus they can still obey this score.
Thank you. We'll give the floor to the others.
If no one else wants to take the floor, one quick question. So from the last point, I understood that basically the information must not be given in a privacy policy, but could partly also be in the law or these decrees, as long as they're available. Or what would you say on that?
Can you please rephrase your question a bit?
Yeah, sure. Sorry. So you say that basically the information that must be provided, as far as I understood, may be partly in the privacy policy, but may also be in the public decree or other information that's made available. Maybe is that your position, and where would you take that from?
Thanks for your question. Answering this, the data controller would like to stress that the GDPR in general doesn't give the exact form how the data subject should be informed about the automated decision making. So the data controller decided that the best way to inform the data subject about such a processing will be creating the two documents, the privacy policy and the decree.
Thanks.
All right. If there's no other question. No. Thank you. Then we can close it. Thank you very much for your team. And with this, we formally close the oral hearing. And thank you very much for both the claimant and the respondent to be participating in such an engaged manner. And with this, I would like to, as per the procedure, shut out of the role of the officer of Radomstan, just to